Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have been keeping you posted of developments in the appeal styled as Richard M. Allen versus State of Indiana. This case has been called the DelphI case. And the appeal relates to Mr. Allen's conviction following a jury trial of the unalivings of two friends, Abby and Libby, in Indiana back in February of 2017. Mr. Allen's appellate brief outlining what he believes are the legal errors entitling him to a new trial and or a Franks hearing, which was denied by the trial judge, Judge Gull. That is a proceeding that attacks the warrant affidavit, sometimes called the affidavit of probable cause. The Fourth Amendment to the United States Constitution has loomed large in Mr. Allen's appellate brief filed December 17th, 2025. Now, the state of Indiana, who is the appellee in this case, they have a right to be heard. Their response to that appellate brief was due in January. However, they obtained an enlargement of time, an extension of time to file their response, and they were given to this month, February of 2026, to do so. However, last week on the 18th of February, they asked for a second extension of time up to and including March 30th, 2026, to respond to the December 17th aforementioned appellant brief. A court order has been rendered in the Court of Appeals of Indiana on the 23rd of February, and it reads as follows. Order. Appellee has filed a verified motion for a second extension of time to file brief. Having reviewed the matter, the court finds and orders as follows. 1. Appellee's verified motion for second extension of time to file brief is granted as a final extension. 2. Appellee's brief is due on March 30th, 2026. This is signed by the Chief Judge of the Court of Appeals of Indiana. If you would like to review a copy of this court order, please go to our sister YouTube channel. There's a description, a link to that YouTube channel in the description to this podcast episode. Now, just a few points that we would like to make under the First Amendment, as we always do, adding commentary opinions. First, the Chief Judge was very clear here. This is a final extension. What will happen thereafter? The appellant, Mr. Allen, is entitled to file what's called a reply. Now, this does not give him the right to re-argue his entire appellant brief all over again. It would be limited to replying to the response. Sometimes a party will feel the other side has put incorrect facts, incorrect law, wants to make a point as to what is in the response. The reply is the time to do that. There's also the possibility that there will be what's called oral argument. It hasn't been ordered or requested as of yet, but either side can make that request to have an opportunity to come forward and have this matter resolved, not just on the papers, but to have an opportunity to go before the appellate court, the Court of Appeals in Indiana, and argue their respective positions. And then thereafter, absent anything else extenuating, there will be a ruling at some point down the line, either affirming, which would be in favor of the state of Indiana, or reversing, which would be in favor of Mr. Allen. We will continue to keep you posted as all developments related to what the final decision will be from the Court of Appeals of Indiana in Allen versus Indiana. Until next time, this is Kathy. Thank you for joining us here today.